Sarah Boone might have an attorney. Hi, everyone. Happy Friday. I was going to do a stream, but as you can see, I need to take a shower. I haven't eaten breakfast yet, and we got a lot of stuff we have to do today. So I want to do a video instead, and I hope you guys are doing well. Hello. But it seems like Sarah Boone might have an attorney. Now, I know there was a motion that was filed that looked a little bit funky where it said that the right to a speedy trial was being violated in Sarah Boone's case. Now, we remember Sarah Boone had the attorney Mauricio Padilla, who was a private attorney representing her, and he waived the right to a speedy trial. And I'm assuming Sarah Boone agreed to that as well. So we could maybe assume that maybe that motion was done by someone who isn't Sarah Boone's attorney. But there's a new motion that was filed today, and this one seems to be what we got here today. So we actually have a couple things that are filed, but we will go over to the defense's motion to continue. And this looks way more legit than the other one that we saw. And let's go through it. I have some case law stuff too that we can kind of over review to see if maybe it could be legitimate. Because remember, I don't know if you guys saw my community post, but Judge Kranick says that there will be no continuance no matter what. And this is when Sarah Boone was going through the many attorneys, and he finally waived her right for representation because they're not going to keep giving her court appointed attorneys and let her choose the one that she finally likes, right? She went through her eighth attorney, Patricia Cashman, and after that, the judge was done. But let's see what this says here. Defense's motion for continuance. This was filed today at 8:54 a.m. I think this is East Coast time. Yeah, East Coast time. Duh, they're in Florida. Hello, Corgi. So it comes now to the defendant buying through the understanding attorney under Rule 3.190F. Why did I read it like that? The Florida Rules of Criminal Procedure and requests that this court grant a continuance of a 3-week juror trial set to begin October 7th, 2024, alleges. So October 7th, that is, yeah, that's like a month from now, literally, like a month, 5 weeks. The defendant is set for a trial by jury on October 7th, 2024. 2. Defendant has just retained counsel, and the notice of appearance was filed on Friday, August 30th, 2024. 3. I guess the notice of appearance has not been uploaded yet because I don't see that. So it was filed today. 38 days remain before trial. Facts. 4. Defense counsel has met with the defendant 4 times at the Orange County Jail. August 20th, 21st, August 26th, and August 27th. I wonder if these were in the logs because remember when we were going through the inmate logs and I was like, oh, it seems like there's an attorney who's been meeting with Sarah Boone. Now, I don't know if maybe there were like other people that were interested in the ad or if it was this attorney that responded to the ad and he has been meeting with Sarah Boone. Number 5. During these meetings, the defendant disclosed potential exculpatory evidence on her phone. Remember, Sarah Boone wanted her phone to be charged. She wanted access to her phone. And then the state was like, well, I mean, we have the Cellbrite, information. You can look at that. But whether or not she actually gets her phone and gets to look through it, I don't think so. I think she probably just gets the phone, but I don't know if they're going to charge it up and let her actually look through it. They'll probably just give her the Cellbrite report to really go through. But I don't know, maybe she can go through the cell phone. Evidence includes photographs, videotapes, calendars, text messages, notes, and witness names and numbers. This evidence will potentially corroborate her anticipated battered spouse syndrome defense under Rule 3.201 of the Florida Rules of Criminal Procedure. 6. The undersigned counsel has spoke with numerous potential expert witnesses covering a range of possible defenses. Counsel is also actively vetting several additional experts upon directives from interested parties. Now, for experts so far, I know that she requested for a neuropsychologist because she wants to talk about the trauma that she endured, maybe from the relationship, maybe from childhood, maybe just trauma in general, and the reason why she acted the way she did, I guess, on the night of the alleged murder. It is the professional opinion of counsel that the retention of one or more of these experts and the development of the aforementioned defenses is a crucial and necessary component of the defendant receiving full and competent representation and due process under the law. Number 8, based upon the conversations that have occurred, counsel has learned that proper diagnosis and development of said defenses requires time not only for administering appropriate testing, but also the necessity of any expert testifying on behalf of the defendant be given adequate time to establish a trusting relationship. That's something that's really hard for Sarah Boone and her previous attorneys, and then be allowed to apply the analytical tools to the information developed from the interviews with the defendant and the supplemented with historical, and documentary information from third parties. Number 9, This process, as described to the undersigned counsel by renowned and respected experts, cannot be accomplished in the time available before trial. Particularly, yes, this is what I was thinking too, given the JAC ministerial hurdles which must be cleared when dealing with an indigent defendant. So again, because Sarah Boone is declared as an indigent defendant, she doesn't have enough money to, kind of like defend herself. So the state of Florida, they have the JAC, which does all the accounting stuff, and they approve like, okay, well, here's the experts that, you can get. Here's the amount of money that you can use for that and X, Y, and Z and stuff like that. We went over the JAC packet that was given, sorry, not the JAC. It was like the JAC pro se packet that was given to Sarah Boone. And at the very end of it, it listed a bunch of experts and then like how much the rates were that were approved and all that stuff. So it's not just a matter of like, okay, let's hire this expert and here's money at the, expert, whatever money I want to throw at, right? It's like, no, we have to go through JAC and they have to approve the rates, the travel, the expenses, and all that stuff. And so doing that within 38 days before the trial happens, yeah, that seems like a hurdle indeed. Number 10, notice of intent to rely on the battered spouse syndrome defense must be filed 30 days before trial. The notice must be filed by September 7, 8 days away. Yeah, that's in 7 days. 11, defendant has been deemed indigent for cause. The defense will need government funds to assist in paying the experts in this field. 12, defense motions will need to be filed concerning the potential Brady material. If I remember correctly, I know that she's had other previous attorneys who has hired experts. I wonder if they're not going to go with those experts or if they're like, well, we'll do those experts plus let's do different experts as well. So I don't know if JAC is going to approve all of this, her having all these different types of experts, unless maybe the experts are completely different and it is very pertinent to, her defense and, the fees are low enough or if the fees are decent enough for them to be able to cover it. But I mean, I feel like she's already had other experts that were hired by other attorneys that represented her. So I don't know if the JAC is going to approve this. We'll see, right? Number 12, defense motions will need to be filed concerning the potential Brady material. 13, defendant has the right to be represented by counsel of her choice. Okay. The defendant attempted to solicit private counsel after the court order dated June 28, 2024. So roughly about 2 months ago. Defense counsel responded to her advertisement and was retained. Number 14, defendant is not trying to delay the proceedings or abuse the process by retaining counsel at this late date. Number 15, defense certifies this motion is made in good faith. So like I said, this motion looks a lot better than the other motion that we saw, right? But let's get to the rest of the stuff backing up their claim. Now, the interesting thing is, I am very interested to see what Mr. Judge Cranick is going to say about this because, yes, Sarah Boone does have a right to be represented by counsel for choice, but in Sarah Boone's case, it was a very unique case, it seems, because she's went through so many different attorneys within the 4-year, almost 5-year time span. And a good chunk of those attorneys, it was because of due to irreconcilable differences. So I don't know if at this point with Judge Cranick saying they're like, okay, I'm not going to delay the trial no matter what. I wonder, even though she's hiring a new attorney at this point, at this time, when it's so close to the trial date, I don't know if this is going to be something that's going to be an exception to what Judge Cranick said. And if he'll be willing to, delay the trial again, just so this attorney can get onto speed with everything that's happening. And, yeah, I mean, it's a lot. Okay, so memorandum of the law. So I do want to read this because I just want to see, okay, like what are they going to cite to really back up his case, right? The memorandum of law. The Sixth Amendment of the U.S. Constitution guarantees that any person brought to a criminal prosecution in a federal court must be afforded the right to the assistance of counsel for his defense. As the Supreme Court recognizes in Ungar v. Sarafite, a district court denial of a motion for continuance may vitiate the effect of his fundamental right. Is this the one that we looked up? I think so. So sometimes when I read these motions and they say the case law, what I like to do is I like to familiarize myself with the case just a little bit, like read a little summary, and then we'll get to the attorneys, in this case, Sarah Boone's attorney, and see how they cited. But a little summary of Ungar v. Sarafite, which I think is interesting. It's about an attorney who was a state prosecution's like witness. And when he went up there testifying, well, they found him they charged him with contempt, essentially. The contempt proceeding grew out of a trial of Hoolan Jack for the conspiracy to obstruct justice and for the violation of New York's conflict of interest laws. Ungar, the guy who was being charged, was an attorney. It was an important prosecution witness familiar with the matters on which the charges were based and immune from prosecution for his testimony on these matters before the grand jury. From the onset of the second trial, Ungar, a hostile prosecution witness, engaged in, let me make this bigger actually. How do I make this go down? From the onset of the second Jack trial, Ungar, a hostile prosecution witness, engaged in much wrangling with the prosecutor over the form of the questions asked and was unresponsive to various questions. Although counsel for the defendant did not object, the witness believed that the prosecutor's questions presented the defendant's case in a bad light or failed to elicit the whole truth. Now, when we watch like cross-examinations, we definitely see sometimes the witness that are testifying in the stand, they are a little bit hesitant in answering certain questions because they feel like they're being tricked into saying something, or they feel like the person that's asking the question is being kind of like doing it in bad faith and, again, not representing the whole truth. So it seems like this is what the witness thought when he was, well, I mean, he's testifying for the prosecution here. And it seems like he didn't like the questions were being asked. On several occasions, the trial judge instructed the witness to answer the questions as they were asked if he could, but not to rephrase the question or to offer testimony gratuitously. Jesus. So we see that a lot on the stand as well when someone's testifying and they don't like the person that's questioning them. It's like, well, I don't like your question, so I'm going to rephrase in a way that's better, and I'm going to answer that one. Or when you're giving way too much testimony than is needed, the judge is like, just answer the damn question, right? But it's hard to do that because you want to make sure your answers are not being misrepresented in any way. When Ungar failed to heed these instructions, the judge admonished him in chambers to confine his answers to the questions, which we hear a lot, and to leave the defense to the accused counsel. He warned the witness that he would hold him the natural consequences of his action. The pattern, however, continued. On November 25th, the third day, Ungar was on the stand. The court instructed him to give a responsive answer to the question of apparent significance to the state's case. Thereupon, Ungar, before answering the question, requested a recess, claiming that he was being pressured and coerced and intimidated into testifying, and that he was being badgered by the court and the district attorney. When this court granted a short recess but refused Ungar permission to leave the stand, the following ensued. The witness: I can't testify. I'm sorry, Your Honor. I'm not in any physical or mental condition to testify. The court: Mr. Witness, no one asked you anything. Nobody is questioning you. You are not testifying. You have taken a recess for about 3 minutes of silence, and we will take a few minutes. The witness: I would like to leave the stand, Your Honor. The court: No, you may not leave the stand. The court: Proceed, Mr. Scotty. The witness: I'm not going to answer any questions, Your Honor. I'm not going to testify in this confusion, and the court nor anyone else will make me testify in this emotional state. I'm absolutely unfit to testify because of Your Honor's attitude and conduct towards me. I'm being coerced, intimidated, badgered. The court is suppressing evidence. The court: You are not only contemptuous, but disorderly and insolent. The judge called a recess, during which counsel for the defendant requested the court to appoint a doctor to determine whether Ungar was malingering or incapable of testifying. Upon resumption, Ungar represented that he was able to obtain his own medical assistance, and the court agreed with Ungar that he was competent to testify and denied the request. Ungar testified for another day without further incident. The Jack trial ended on December 6, 1960, and during the afternoon of December 8, 1960, Judge Sarafite, the trial judge, pursuant to the New York procedure governing non-summary trial of contempt, had served Ungar a show cause order charging that Ungar's remarks from the stand on November 25th constituted a willful and disruptive contempt of court, and ordering that the appellant appear on December 13 at 10:30 a.m. So it seems like December 8 was when they charged him with contempt, and the judge is like, okay, I want you to appear at December 13th, so about 5 days afterwards. Judge Sarafite, presiding at the hearing, denied several motions for a continuance, and Ungar retained counsel was permitted to withdraw upon informing the court that he had agreed to undertake the defense only if Ungar could obtain a continuance. Okay, so charge 5 days later has to appear at court. However, the guy that was being charged, his counsel, I don't know if this is allowed anymore, but his counsel was only going to be his attorney representing him if they would grant a continuance. And because the same judge, didn't grant the continuance, then the attorney was like, okay, well, I only agreed to represent you if there's a continuance. Since there's no continuance, I'm not representing you. After exhibits materials of the charge were admitted to evidence, Ungar was asked to defend. So I guess Ungar had to defend himself. I mean, he is an attorney. He does have some experience back then. He declined, arguing that a continuance in a hearing before another judge should be granted. The court found Ungar guilty of contempt and, taking into consideration Ungar's emotional state from the stress of the Jack trial, sentenced him to 10 days imprisonment and posed a fine. So, yeah, I mean, in this case, it's, pretty different from Sarah Boone's. Sarah Boone, again, like I said, has had about 4+ years. She cycled through many attorneys. Now, maybe Judge Cranick will see the situation as, the new situation where there's a new attorney representing Sarah Boone, if that is enough, cause to have a continuance and not have the original October 7th trial. Sorry, my voice. Whoa, I have no water here. It's early. Interesting case. Now, let's see what Sarah Boone's new attorney cited in what we just talked about. In Ungar, the Supreme Court stated, the matter of continuance is traditionally within the sound discretion of the trial judge, so Judge Cranick, and is not every denial of a request for more time that violates due process, even if a party fails to offer evidence or is compelled to defend without counsel. So it is not every denial of request for more time that violates due process, even if a party fails to offer evidence or is compelled to defend without counsel. This sentence got me in a brain loop for about 10 minutes. I had to rewrite the sentence, and I'll rewrite it because maybe, I don't know, sometimes when I read things, I'm just like, what the hell are they saying? And I have to rewrite it in order to understand or try to understand what is the sentence trying to say. So I'll read it to you guys normally, and let me know if you guys understand it the first time. Contrary-wise, a myopic insistence upon expeditionists in the justifiable request for delay can render the right to defend without counsel an empty formality. So I rewrote that as contrary-wise. So on the contrary, a myopic insistence, so a narrow-minded view, insistence on expediting in this face of justifiable requested delay can make the right to defend with counsel an empty formality. That's how I had to rewrite it. Or I guess I could just show you right here. These are my notes that I have right here. This was the original sentence, and this was a sentence that I tried to translate for me to understand it better. So in a way, it's saying that, if you are narrow-mindedly pushing on expediting, even though there is a justifiable request to delay, essentially the fact that you have a right to counsel just may seem like an empty formality, because you're just really pushing on expediting the case to happen. And who cares if this person has a counsel to properly represent him, to properly review the materials and all that stuff. That's how I understood it as, okay? But yeah, that sentence was a little bit hard for me to kind of wrangle with. Reading is a tough one for me sometimes. To the right of the assistance of counsel not only reaches at trial stage, but extends to sentencing as well. Jones v. United States. Further, the Supreme Court has stated that implicit in this right to counsel is a notion of adequate time for counsel to prepare for defense. Avery v. Alabama. What was Avery v. Alabama about? Oh, okay. I remember this one. Yeah, I remember this one. Okay, Avery v. Alabama. Now, this is like back in like the 30s or the 40s or something. Yeah, back in the 30s and 40s. I think someone was accused of murder. They were accused of murder. They were caught. And I guess back in the day, if there's a trial, I mean, it happens pretty quickly. I don't know. I wonder when was a right to a speedy trial, to waive your right to a speedy trial. I wonder when that became a thing. Petitioner was convicted on an indictment filed in Bibb County Circuit Court for murder alleged to have occurred in 1932. Oh, this was back in 1932. He was found and arrested in Pittsburgh, Pennsylvania shortly before March 21st, 1938, so 6 years later. On that date, Monday, he was arraigned at a regular term of the court. 2 practicing attorneys at the local bar were appointed to defend him. Pleas of not guilty by reason of insanity were entered, and the presiding judge set his trial for Wednesday, March 23rd. So imagine being arrested on March 21st, and then 2 days later is when you're supposed to stand trial. So duh, in this case, of course, like the attorneys didn't have time to prepare. The case was not reached Wednesday, but it was called Thursday the 24th, at which time his attorneys filed a motion for continuance on the ground that they had not sufficient time and opportunity since the appointment to investigate and prepare his defense. Affidavits of both attorneys accompanied the motion. And by the way, guys, I just want to remind you guys, I don't have any legal background or anything. It's just that sometimes when I read these motions, I'm like, oh, well, let's read about the case as well, since the attorneys are citing it. One attorney's affidavit alleged that he had not time to investigate and prepare the defense because he had not been actually engaged in another trial from this time. Because he had actually been engaged in another trial from this time of his appointment at 2 p.m. Monday until 9 p.m. That evening, his presence has been required in the courtroom on Tuesday, March 22nd, due to employment in other cases, but not actually tried. He has been detained in court Wednesday, March 23rd, waiting for petitioner's case to be called. But after his appointment, he talked to the petitioner and had serious doubts as to his sanity. The affidavit by the other attorney stated that he too had not proper time and opportunity to investigate petitioner's case because of his employment in the other pending cases. Yeah, I mean, who would have enough time to do this? Like, you have 2 days. I'm reading this right? Same year, not like a different year. It seems like 2 days later, after being arrested, it's like, okay, let's have your trial. So, yeah, interesting stuff. Things that happened back in the day. Oh, and this is what Sarah Boone's attorney cited from Avery v. Alabama. I think I haven't read this yet. The prompt disposition of a criminal case is not to be commended and encouraged, but in reaching that result, a defendant charged with a serious crime must not be stripped of his right to have sufficient time to advise with counsel and prepare his defense. So I wonder if that applies to, Sarah Boone's case, even though she cycled through many other counsels. And then now she has a new counsel. Does that apply to her newest counsel then? But like I said, I mean, I think it is legitimate that, you have a new attorney getting on the case and they're like, oh, I only have 38 days to prepare. That's not enough time. But like I said, with Sarah Boone's case, it's very different. It's because she's already had her cycle of attorneys. And yeah, I don't know. I'm interested to see what Judge Kranick is going to say and what his ruling will be. I wonder if the state should have a chance to respond, right? It should be like the state responds to this and then the judge makes their ruling. Now, if you guys remember, Sarah Boone does have a hearing next Tuesday. So I'll keep taking a look at the court's calendar to see if, they will maybe like add include this motion in that hearing, or if that will be scheduled for a different time. They're probably just scheduled for a different time, I guess, right? I don't know. Now that we have a new attorney in here, it's mixing things up. Now, before we go, we do have new notes. Inmate notes. What do we have with Sarah Boone so far? Corporal Pagan and I engaged in discussion with inmate Boone in the FDC briefing room regarding several matters. We addressed the proper channels for submitting request forms, emphasizing that they should be directed to the housing officer or shift supervisor rather to the county legal counsel Scott Chevino and Captain D. Giovanni. If you guys remember, the legal counsel is the one that was representing the jailhouse, and that guy was super snappy. But I don't think he was overly snappy. I think he was just trying to, with a person like Sarah Boone, you kind of have to like establish your boundaries and put your foot down. Otherwise, she'll try to steamroll over you. So I think that's what he was trying to do, because he probably knows about Sarah Boone, her history, her past. And so I think she was trying to get the contact number of him, of the legal attorney, and, Captain Di Giovanni, because, these are the people that she knows that has like the power, I guess, to grant her stuff. And she wants to supersede normal procedures by just requesting things from them directly, or like maybe submitting forms and complaints to them directly. But it seems like the jailhouse is like, oh, this is not the right way to do this. You actually have to submit it to a housing officer or a shift supervisor instead. Action taken. Inmate Boone, who has been incarcerated since 2020, is already well acquainted with the established procedures and confirmed her understanding of them. Inmate Boone expressed a desire to have a tablet available for her use throughout the day. Oh, she wants a tablet too? Action taken. We clarified that tablets are accessible to all inmates on a standard schedule, 7 days a week, ensuring reasonable access without the need of further action. The inmate also requested that writing materials such as pens, papers be replenished as necessary. Yes, please give her writing utensils and papers and stuff. Action taken. Request denied at my level escalated to the appropriate authority who provided guidance and compliance with our policies. Inmate Boone was directed to request her items via inmate request forms to the law library department. Oh, there is a law library department. I remember people were like, Corgi, she has access to the law library stuff, da-da-da. And I was like, does she? Does she really? I wasn't really sure. I wasn't sure if every jailhouse had a law library that, they had access to. I don't know. Inmate Boone demonstrated a willingness to engage during our dialogue. However, she consistently paraphrased my statements while introducing details that were neither mentioned nor implied. Consequently, I concluded the conversation, dismissed Inmate Boone back to her unit due to her patronizing tone and her persistent misrepresentation of my remarks and information I aim to communicate. Yeah, that's usually a common theme with manipulators and people who try to gaslight you, and then people try to take your own words and use them against you. I can see that with Sarah Boone. Ultimately, Inmate Boone expressed her disagreement with my stance and decision-making indicating her intention to file a motion with the judge assigned to her case. All right, and that's about it. I hope you guys have a happy Friday. I will see you guys next Tuesday. I forgot. I think it's Tuesday. Yes, I will see you guys next Tuesday for Sarah Boone's hearing. And maybe at that hearing, the judge will address the motion for continuance. Because I think court stuff, I don't think things just happen, like, just because they get it in the computer system, I don't think decisions are made then and there. I feel like usually, I don't know, it's like, okay, we all have to go to court, address it here, and then schedule a time, and then blah, blah, blah. I don't know. It's like things happen on a slow pace, you know? But that's just how it is, right? Just got to make sure everyone's there, everyone's present and stuff. But I don't know. Maybe they will decide to make a decision about this motion for continuance on Tuesday. But like I said, I wonder if the state needs to reply to that. I'm assuming yes. I'm assuming the state has to reply to see if they object to the motion to continue, or if they're just like, okay, we agree, go ahead, do whatever it is you need to do. So far, it seems like the state has been pretty, well, I mean, we don't know behind the scenes, but from the hearings, recent hearings where Sarah Boone had to go pro se, it seems like the state has been trying to work with Sarah Boone with certain things. Like, for example, when Sarah Boone didn't know how to like do certain things, the state would like kind of like patiently explain things to Sarah Boone, even at some point offering their experts to Sarah Boone. Although I don't know if you want to use their experts. If you were defending yourself, you probably want your own experts, right? And then also when Sarah Boone did not want to have the evidence, the physical evidence viewing in open court, the state, even though the judge had already rejected Sarah Boone's motion, the state afterwards was like, hey, you know, actually, like, I think we can figure out a date where we can meet together. We can do the physical evidence viewing without having the media there, without having other people there and stuff like that, it seems. So, but, you know, I did see that on Tuesday's hearing, that's where the physical evidence viewing is going to happen. So I'm like, oh, wait, did something happen between Sarah Boone and the state? Like, did they not arrange for a time to do that? And something fell through, and that's why they're doing it in court instead? Or is that just still on the calendar and has been updated yet that they're not going to do that? I don't know. I'm not quite sure. Lots of I don't knows, you know? Just how it is. All right, y'all. I think that's it for today, though. I hope you guys have a good, happy Friday. Enjoy your weekend. And I'm excited. You know, if Sarah Boone has an attorney, I'd rather have her have an attorney. Like I said, you guys have heard this so many times from my mouth, and I'm just going to repeat it again because I don't care. I'd rather have her have legal representation. I'd rather have the trial go smoothly, or as smooth as it can. Because usually, you know, lately a lot of trial stuff has been kind of bumpy. I don't know what's going on, you know? A lot of crazy drama stuff with all these trials. But yeah, I want her to have legal representation. You know, let's get her someone to take care of all the legal stuff, so she's not going up there and fumbling and trying to defend herself when she has like no legal background and all that stuff. But yeah, we'll see. I mean, what do you guys think? Do you guys think the judge is going to grant her a continuance? I mean, Judge Koenig was very firm when he said that. I think he even wrote it in his, did he even write that as well in his, when he waived Sarah Boone's right to counsel? Well, he waived her right to a, oh shit, I can't even think of the word. I'm just so hungry right now. That's what happens when I'm hungry. All right, I'm just going to end it here because I'm just going to ramble. All right, y'all. Bye. What do you guys think? You think the judge is going to grant it?